In Berkeley, I'm Dennis Bernstein. You're listening to Flashpoints on Pacifica Radio. And we turn our attention back to Julian Assange and WikiLeaks. And in fact, their case and Julian Assange's attorneys were in a British court today to talk about, well, a whole bunch of stuff having to do with illegally, that's what they're asserting, keeping him, undermining information, important information, and illegally keeping him hostage there at the embassy. Joining us to talk about this story is attorney Estelle Dehon, who represented Julian Assange in court today. Welcome to Flashpoints. It is good to have you with us. Can you begin, if you will, by just setting this up? What is the background? Help people understand what got you in court today.
Thank you very much, Dennis. It's great to be with you. So the background to this case is that it's to do with access to information. You'll be aware from the United States that there's legislation which can allow individuals to have access to official information held by public authorities. And we have the same type of system in the United Kingdom. And that's available for any individual to make a request to a public authority to be provided with information. And my client, who is the extraordinary Italian investigative journalist Stefania Maurizi, who works now for La Repubblica, made a Freedom of Information request to the Crown Prosecution Service for information about Julian Assange. And in particular, she was asking for copies of correspondence between the Crown Prosecution Service and the Swedish Prosecution Authority, and any correspondence with the U.S. State Department, the Department of Justice, or the state of Ecuador. Obviously, looking to the situation which has occurred with Mr. Assange being arbitrarily detained, which is what the UN body determined, being arbitrarily detained in the Ecuadorian embassy.
And in that regard, you are seeking certain information, and there were revelations just a week or two ago that some of the key information that you are seeking has been destroyed. Is that correct?
Yes, so information has been coming out piecemeal. Initially, the Crown Prosecution Service refused to provide anything. And then as this appeal has been going forward before the tribunal, they started to release information. And just last week, we were informed, when yet further documents were released to us, that the email account of the main lawyer who dealt with the Crown Prosecution Service case and was corresponding with the Swedish Prosecution Authority and with whoever else wanted to correspond, that lawyer's email account was deleted when he retired from the Crown Prosecution Service in 2014. And one of the things we were asking today was how that could possibly have taken place. Because we've variously been told that this was a case where the extradition matter had come to an end. You may be aware that in the Supreme Court in 2012, the arrest warrant for Mr. Assange was upheld. And so on one hand, the Crown Prosecution Service is saying, well, at that point, the extradition matter that we were dealing with came to an end. And so it's not surprising that when the lawyer retired, his email account was destroyed. But on the other hand, they're saying, as a way of resisting full disclosure, but the extradition matter was ongoing because Mr. Assange had not been extradited. He went into the embassy, and so there was ongoing correspondence and advice. And our simple question is, what is the right answer? Because if this was a case that was closed, so that emails could be deleted, then that goes to the public interest in releasing as much information as possible in relation to a closed case. But if this was a case that was ongoing, then on what possible basis, what could the justification possibly be for deleting the email account of one of the key people who was involved?
We are speaking with attorney Estelle Dehon. We're talking about a case that's in the British courts today in which Julian Assange, through his attorneys, is asking for all relevant material having to do with him being held captive, wanting to get to the bottom of what really is the motivating force. So could you talk a little bit about the kinds of documents that have already been released and what it is that you're looking for, hoping that they're not already destroyed?
Yes, absolutely. So a number of pieces of correspondence between the Crown Prosecution Service and the Swedish Prosecution Authority have been released. Some of them only with a bit of redaction, some of them very heavily redacted. And one of the things that we're arguing in the tribunal today and will argue tomorrow is that these redactions should be removed. And that correspondence really looks at the flow of information from Sweden to the Crown Prosecution Service and back again about Mr. Assange. And in particular, it revealed, and this my client Stefania obtained actually from the Swedish Prosecution Authority before she made her request to the Crown Prosecution Service. The information revealed that the Crown Prosecution Service had advised the Swedish prosecutor not to try to travel to the United Kingdom to interview Mr. Assange, despite the fact that that offer had been made. And that advice was provided very early on in January 2011. And one of the things that we seek through the information request is to understand why that advice was given at that time, why the advice didn't change when things started to drag on, and why the advice seems to remain the same despite the situation arising with the Ecuadorian embassy. And I must explain that we rely quite heavily on the United Nations Working Group on Arbitrary Detention, who made a determination as a result of a complaint by Mr. Assange. They made a determination in December 2015, so some long time down the line, that they considered Mr. Assange was being arbitrarily detained in the Ecuadorian embassy. Now, we don't explicitly say as part of our case that the court that we're in front of, the tribunal that we're dealing with, has to come to the same determination. But what we say is that because this very well-respected United Nations body came to that conclusion, that is highly relevant to the correspondence and the advice that was flowing still between the Crown Prosecution Service and the Swedish authorities. And we still haven't seen any indication that that UN decision changed the way that the authorities were dealing with Mr. Assange, changed the scenario where they were refusing to come and question him, and what the impact of that decision was. And one of the revelations from the court case today was that the Crown Prosecution Service certainly did not consider in their day-to-day running that the determination by the UN panel made any difference to the way in which they were treating Mr. Assange's case or the way in which they were advising the Swedish Prosecution Authority. And we find that quite surprising and quite disappointing, but we're still persisting with the request to see if any of the information that's been provided, any of the correspondence, can be unredacted so that we understand what information was being provided and why the Swedish prosecution decided initially not to question Mr. Assange in the United Kingdom and then changed their minds and tried to question him.
Now, in terms of the destroyed documents, the document destroyed by the Crown Prosecution Service, they're saying that they don't really have the slightest idea what documents were destroyed or the implications of those documents, right? Do you believe that?
Correct. I think I do believe that because, as I understand it, the email account has been completely destroyed. There's no way of getting it back. There's no way of understanding what was in there. And at a very high level, we know that the entire email, whatever was on that email account of that lawyer, with correspondence with anybody to do with the Assange case. That has gone, and all that remains is the correspondence that was printed out and kept in hard copy in the correspondence files. And we have been released. We are told, although it may be, and there was another revelation today, which I'll tell you about in a minute, but we have been told that all the emails that now exist in hard copy, we have been provided, albeit very heavily redacted. The further revelation today, though, was that despite on at least 2 occasions the Crown Prosecution Service assuring us, assuring the tribunal, assuring the Information Commissioner that they had searched and found and released all the relevant documents of correspondence between the Crown Prosecution Service and the Swedish authorities, it turns out today that they may have uncovered some further emails and they are looking to do some further disclosure. So even now we don't have a full picture of just how much material there is, and we certainly don't have a proper understanding of what that material contains because of the redactions.
Let me ask you this. Great Britain has worked very closely with the United States on various kinds of intelligence breaches and just generally working together. Is there any indication that the big hand of the United States has been forcing the kind of behavior that led to, for instance, resisting allowing the Swedish ambassador to show up to do the interview and to perhaps find out that this is really nothing and this case should be over?
So there isn't any information. There's certainly nothing in the information that's been disclosed to us. And we have had no indication of that in court, either in the evidence or in the documents. But what we don't know, and this is the second part of our request, what we don't know is what the documents that have not been disclosed might show in that regard. We just don't know whether there has been any request or any influence exerted by the United States. And a key part of my client, Ms. Maurizi's request, was for correspondence between the Crown Prosecution Service and the U.S. State Department and the U.S. Department of Justice. And the response that we had today was essentially a blanket no. The Crown Prosecution Service will neither confirm nor deny whether such correspondence exists, and they are taking a very in my view, extreme position of a blanket response that is a firm no. And one of the things we will be asking the tribunal to rule on is that, in my submission, is not a lawful approach for them to take. Our freedom of information law doesn't deal in blanket bans. It doesn't countenance that kind of secrecy. Our freedom of information law looks at the public interest and makes a proper determination, an objective determination about whether information should be confirmed or denied. And that process simply hasn't happened in this case. So I can't really shed any light on any role, if such a role existed, that the United States may have played. But we hope that the tribunal will assist us in getting the Crown Prosecution Service to release some information, if there is any, in that regard.
You're listening to Flashpoints on Pacifica Radio. We're speaking with attorney Estelle Dehon. She's in Great Britain now. She was in the High Court today, arguing on behalf of Stefania Maurizi, who is a very well-known Italian journalist who has worked closely with Julian Assange in getting out some of the most significant of the work that Assange has been up to in terms of releasing documents that throw light on stories, on situations, on actions by governments and corporations that affect all of us. He has certainly been very high profile, has gotten a lot of attention, and clearly here in the United States there are many people in Congress, in the administration, that would like to see Julian Assange literally executed as a traitor to the United States government. I don't know, he's not a U.S. citizen, but that doesn't seem to stop them either. I want to ask you, Attorney Dehon, what is at the core? You've spent a lot of energy on this case. What's at the core for you? What do you think this is really all about here?
So two things. First, can I just explain? We weren't before the High Court today. We were before a body called the Information Tribunal. And in the United Kingdom, information requests like this one and appeals like this one are dealt with by a specialist tribunal who can hear evidence and make a particular assessment based on information law. We may end up in the court system if we don't get the type of decision we think we should in the tribunal system, but we're still at the very early stages. In terms of what I think is at the heart of this case, I said this in opening to the tribunal. At its heart, I think this case is really about the clash of free speech and freedom of the press versus an official culture of secrecy. One of the great hopes of information, the information access regime, which was put in place in 2000 in the United Kingdom, was that it would foster a culture of openness, but there wouldn't be any area where the stock response was to shut down, not to engage, and certainly not to engage with the media. And it's unfortunate that I don't think it's had that effect. I think in certain areas, especially like extradition matters, it seems that the ethos of freedom of information and access to information and the important watchdog role that journalists play just simply hasn't featured on their radar. So you have that on the one hand, and on the other hand, you have the very particular case of Julian Assange. And it's clear from the limited material that we've been provided that the Crown Prosecution Service said right from the beginning, this is not just another extradition request. They weren't dealing with it on that basis. And that's purely because of the personality involved and because of the work that Assange has undertaken with WikiLeaks. And that clash of a very open, non-state organization taking state documents and publishing outside of what a lot of countries are familiar with or used to, that clash on the one hand of that individual with all, as you pointed out, with all the controversy and all the official concern about that, versus the culture of secrecy, I think is at the very heart of this case. And my hope is that in some small way, this information tribunal will turn around to the public authorities who still look to be secret first and say to them, that's not the right approach, that you have to consider properly and carefully the public interest in disclosure. And where you've got a case as this one, which our own information commissioner, who's the regulator in relation to information law, our own information commissioner has acknowledged there was a significant public interest in the information requested by Ms. Maurizi. Where that's the case, you just can't close up like some kind of sea anemone and refuse to provide information. You cannot have that as your stock response. And so my hope is that the tribunal will say something to make those types of organizations take proper account of access to information.
Wow. So you, at the core here for you is that you are defending free speech, and you would refer to Julian Assange as a journalist?
So what we've referred to him, how we've referred to Mr. Assange is as follows. We consider that he's an editor. Although the UN body described him as a journalist, what we consider is that Mr. Assange is an editor, and that's what he performs as his role. And Ms. Maurizi explained this in evidence to the tribunal today. She said that he, as traditional journalists do, he speaks to sources and he obtains information. He and WikiLeaks perform that function. And then he and WikiLeaks seek to validate that information, to understand whether the sources are good and the information that's been provided is good. And so that's the editorial role. And then he works with media partners to release the information, initially through the media partners and then generally through WikiLeaks. And that process, while it doesn't fit necessarily easily in the traditional media process, is certainly, in our view, a type of journalism, and we have characterized him as an editor, and WikiLeaks as a journalistic organization. And certainly Ms. Maurizi, in her role as an investigative journalist working with WikiLeaks, is a very clear example of one of those defenders of democracy, a watchdog within the media, looking to oppose corruption and shine a light where one has not been shone before.
I like very much what the courageous Israeli journalist Amira Haas said about the role of the journalist. She reports from the occupied West Bank and receives hell for it all the time in the Israeli press. But she says the job of the journalist and the editor is to monitor the centers of power and report back to the people. I would imagine you think that's the role that Julian Assange helps to play.
Absolutely. And that was our evidence to the court today through Ms. Maurizi. That especially in an era where states exercise very significant power and organizations like media organizations, however independent they try to be, can be influenced by that. The type of non-state, non-traditional actor, such as WikiLeaks, performing the role where information is released not just to journalists but to the public at large, so they can look at the source documents and make up their own minds. That, in Ms. Maurizi's evidence, is an important element of a democratic watchdog.
Well, we hope to catch up with her in a few minutes. We appreciate you taking the time, Attorney Estelle Dehon, for helping us understand this incredibly important case. You're going to be back in court tomorrow, right?
Yes, we're back in court tomorrow for closing submissions. So some of it will be along the lines that I've just discussed with you, and some of it's going to be the more boring, technical, boring I say in quotes, I find it fascinating, but the more technical legal argument about the exemptions applied in the Act. So closing submissions from me, from the Crown Prosecution Service, and from the Information Commissioner tomorrow.
Well, it has been very enlightening speaking with you. Thank you for taking the time out to be with us on Flashpoints.
Dennis, it's my very great pleasure.
Bye-bye now.
Bye-bye.
In Berkeley, I'm Dennis Bernstein. You're listening to Flashpoints on Pacifica Radio, and we continue our coverage of the hearing held in Great Britain today regarding Julian Assange and the British government holding back key documents that could shed light on a case that should have ended a long time ago, but the Brits have been holding back, apparently working with the U.S. government. Now it's been revealed that they actually have destroyed crucial documents, but there was a hearing today. We spoke with the lawyer. Now we're delighted to have with us again Randy Credico, special correspondent on this story. He was in the hearing today in Great Britain, where he is now in his hotel, and he has just come from a long meeting with Julian Assange. Randy, welcome back to Flashpoints. What was the mood? Tell us a little bit about the hearing and Assange's response to it.
Well, the hearing was amazing. The hearing, I was totally stultified in a positive way by the proceedings itself. I've never seen anything like of a three-judge panel, which are basically like tantamount to a court of appeals, but they don't have allegiance to the government. These are all attorneys that are practicing attorneys that are placed on this court, and they hear the evidence and they act in a legal way. And what was astounding today was the revelation that the British government had withheld information that would have exposed the British complicity, not complicity, but the blame for having the Swedish government not interview Julian Assange because they knew that there was nothing there that was there. In other words, wouldn't have been charged with anything if they had actually interviewed him. They didn't want him to interview Julian Assange. They didn't want anyone to interview from the government, from Ms. Nye's office, to interview Julian Assange because they knew that would be the end of the story. That would be the end of the case. So they had a pretext to keep him incarcerated inside this building until they could figure out what to do next.
And so they kept the Swedish officials out, and
Yes, and those documents came to light yesterday. I think the Guardian got it, and not just that, but they've kept a lot of transmissions between the Crown, it's called the Crown Prosecutor Services, and the U.S. government and the Ecuadorian emails. They should be out there. They should be part of discovery. And right now they are in very bad shape, no matter what happens with the decision of 3-judge panel, which is a pretty, I would say, nonpartisan panel. And I believe they will rule in Mr. Assange's favor if you look at the facts. But what they have done, what the Crown Prosecutor Services has done is prevent information going to his lawyers and to the public about these crucial situations that transpired between the government and the Swedish government. They didn't want the Swedes to come here because they knew he would be exonerated. So they wanted to. He's basically been illegally detained now for 6 years, based on this maneuver by the Crown Prosecutor Services.
All right, let's talk about, meanwhile, despite the fact that Julian Assange is again held hostage at this embassy, he has been incredibly busy, hasn't he? You saw him today, Randy, and you came into the middle of a sort of a firestorm of him doing key reporting on what's been going on in Catalonia. You want to talk about that?
Yes, I do, and I got to say, thank you for interviewing Liz Castro the other day. Believe me, everybody here is talking about that. That was cutting edge.
She was the interview from Catalonia.
Cutting edge journalism by you. You're the only one that has presented that in the U.S. You had Liz Castro, who's in Brussels right now. And so I was I spent like 3 hours with Mr. Assange today. I think he's very optimistic by the court proceedings. But I really went there because I plan to go to Catalan in the next couple of days and report for Flashpoints from Catalan, this very dynamic situation, the explosive situation that's happening there right now. And it's because of Mr. Assange. Forget about WikiLeaks. They've done some, publications on this, but Assange himself has acted like a wartime reporter. Every 20, 30 minutes, you will get what's happening. And a lot of people are following Mr. Assange's reportage out of the embassy from Catalan. In other words, what's going on in Catalan. If you want to know what's going on, forget about MSNBC and the mainstream press. You got to listen to Flashpoints, or you got to take a look. And we all get it from Julian Assange, who has been moment by moment updating the world on what's happening in Catalan. This is why he poses such a danger to the powers that be, is that this man is a serious journalist. He's uncompromising, and this whole affair in Catalan underscores the value of having a free press. And Julian Assange is the avatar of what is a free press, as is your program. And I must say that he is listening right now. I'll make sure I say the right thing. But I get my information from him. I'm going to Barcelona in the next couple of days. And who am I going to get information from, to get a briefing from, but from him? Because he knows more than any Western journalist out there. Nobody's covering it but him and you.
So he has got an operation going on there. How does he manage to do this? What's the technology?
First of all, people. His technology is that he has the people send him information. I believe he gets information. He gets footage. Like the other day, there was 1 million people marching 2 days ago in Barcelona. 1 million in a country of 10 million. 1 million marching the other day. So you got that footage. Somebody sent that to him. He's a clearinghouse, basically, for internet and for video and other forms of newsworthy items out of Catalan, out of Spain, not just Catalan, but Spain. The Spanish government and its lackey mouthpiece, El País, has basically made Julian Assange a target, enemy number one, because he's been out there informing the world on what's going on. If you had to go by El País, it's like going on the information being spread by MSNBC or by CNN. You have to get around El País and this other news outlet called ABC and go to follow him at Julian Assange on Twitter, and you will get up-to-the-minute reports on the ground of what's happening. I've never seen anything like this. This is a novelty when it comes to journalism, that if you go to Julian Assange's Twitter account, you will be able to find out what's going on in Catalan and in Spain, and what's the motivation of the Draconian government of this guy Rajoy, and what's happening in Brussels. I mean, he gave me a history lesson and a civics lesson, a political lesson today on Catalan that I probably couldn't have received from a professor from the University of Madrid.
Again, you're listening to Flashpoints on Pacifica Radio. We're speaking to Randy Credico in Great Britain. He was at hearing today, Freedom of Information Act, really hearing on the release of key documents, I guess the ones that are left that haven't been destroyed, that pertain to the way in which the British government engineered to keep Julian Assange in prison in the embassy, I guess, as they do business for the United States government, who really wants to arrest Julian Assange. And if some of the folks here in the U.S. have their way, they'll execute him for treason. You say his attitude, his spirit is strong and good. Yes. He's working very hard. Is he confident that these hearings that are taking place now will finally lead to his freedom? Where is he on that?
I believe at this point there's no way he can lose on these hearings. Either the British government suppresses information, they get away with it, or the British government releases information. Either way, they're screwed. Either they are working hand in hand with the U.S. government, lackeys of the U.S. government, or they are free to be honest about the relationship with the U.S. government. Either way, it will redound well for Mr. Assange, who has, if they had not done this, if they had not suppressed what they was released today by The Guardian picked up on it finally, but what they did was to keep him in limbo by telling the prosecutor in Sweden not to interview him in the UK. Because if they had done that in 2012, he would have been exonerated then, and they would have lost their pretext to keep him inside that embassy. So in the meantime, he spent $350,000 on bail. He had 600 days. He had to wear a ankle bracelet and go back every single day in front of a British, I guess something tantamount to a parole officer. And then finally, when he left the embassy, into the embassy in 2012 on June 17th, and now it's been almost 6 years, he has been there. And the British government has kept that secret. This is a vile, this is an evil act at the behest of the U.S. government. There's no question about it. The U.S. government has their hand in this. They tell the British government tells the Swedish government wants to be part of the team.
Well, we only have 30 seconds left, but what do you think Julian Assange is going to do after he gets out of the embassy? You think he'll continue winning WikiLeaks?
He's going to do a 1-hour interview. He's going to do a 1-hour interview with someone that he can trust, because so many journalists, even people that we know, have double-crossed him. But he will be doing a interview with Dennis Bernstein on KPFA, because he is a fan of this show, and he will be listening tonight, and he gives his regards to you and to your staff for basically being in the same boat. You have put yourself on the line, Dennis, and he appreciates that, and he will be on your show very soon. I can tell you that for sure.
Randy Credico in Great Britain, on his way to Spain to see what's going on there. We'll talk to you then, Randy. And that's it. You are listening to Flashpoints on Pacifica Radio. Stay tuned for more. I'm Dennis Bernstein.